Welcome to today's panel discussion. We are very glad to be here in Helsinki, and thank you to the organizers for the kind invitation to moderate this panel. Before we dive into our discussion on public-private arbitrations, how to strike the right balance between public interest and private proceedings, I will shortly introduce you to our speakers. To my left, to your right, Professor Stavros Brekoulakis. He is professor in international arbitration and commercial law at Queen Mary University of London, teaching courses in international commercial arbitration, international construction contracts and arbitration, and international commercial litigation and conflict of laws. He's author of numerous publications that you might well know, and he is attorney acting as counsel, arbitrator, and expert in arbitrations for more than 17 years. To my right is Galina Zukova. She is partner at the Paris-based firm Bélot, Malan et Associés. She concentrates her practice on international commercial and investment arbitration. She acts as counsel and arbitrator. She's a member of the Latvian and Paris bar. Prior to her work in law firms, she worked as counsel at the ICC International Court of Arbitration. She's currently a member of the ICC Court. She's also a board member of the Finland Arbitration Institute and associate professor at the University of Versailles, Saint-Quentin, and Riga Graduate School of Law. To my very right is Robert Lambert. He is a partner at Clifford, based in London. He's specialized in international arbitration and litigation with a special focus on construction, energy, international engineering, and corporate disputes. Robert is experienced as arbitrator and counsel in arbitrations. And Eva Storskrubb. She is a dispute resolution counsel in the Stockholm-based law firm Roschier. Specialized in dispute resolution, she has a law degree from the University of Helsinki, an LLD from the European University Institute in Florence. She's associate professor at the Uppsala University, specialized in EU procedural law. She publishes quite a lot in this field and is a board member of the Law Society of Finland. Our hot topic today is public-private arbitrations. Well, partnerships between the private and public sectors have a long history. Even during the 16th and 17th centuries, European sovereigns began concession programs in road paving, public transportation, and canal construction. Nowadays, almost every state relies on private actors to perform public functions or public services, be it the provision of water, electricity, outsourcing services in very sensitive sectors such as military services, immigration, social welfare, and healthcare. A very recent example that you might know as it was spread in the media is the Chinese Belt and Road Initiative that was invoked by the Chinese government and is a huge infrastructure and trade project connecting Asia with Europe and Africa, following the land and maritime routes of the ancient Silk Road. A construction and infrastructure initiative on this scale involves already more than 70 countries with private actors that have concluded contracts or are on their way to conclude contracts with Chinese public entities. Such projects involve issues of public interest and very likely will generate quite a lot of disputes in the future. and most of them will be resolved through arbitration. While in investment arbitration, the representation of public interest is more often addressed, in the field of commercial arbitration, these concerns are usually absent and arise mostly when it comes to public-private arbitration. We see currently quite an increase of public-private contracts and mostly favoring arbitration over court proceedings. Such contracts have implications for the public interest. They are conducted within a purely private law framework and, in most times, in a confidential way. But wouldn't the public have the right to know how the government spends the money, and in particular the taxpayers' money? Should governments, public entities, be subject to certain restrictions, specific regulations when it comes to arbitration in order to safeguard the public interest? We will discuss today with our panel of speakers the concept of public interest. We will dive into a discussion when you need to balance between public interests and private proceedings and look into transparency, public policy, and the right to access to information. We will examine also the current developments in certain jurisdictions that take public interest into account. And of course, we will welcome your comments and questions from the audience, and will certainly give you the opportunity to do so. Let's start with the first question that I have, and this is going to you, Stavros. As I said in my introduction, there is a rise of public-private arbitrations. Do you agree, and what are the reasons behind that?
Well, thank you, Patrizia. First of all, I definitely think that there is a certain rise in the public-private contracts, and therefore in public-private arbitrations, and I will use statistics to support this, but also then very briefly explain why I think this is the case. If you look into the ICC numbers, for example, you see in 2006 the number of arbitrations involving state or state entities were 62. 10 years later, in 2016, the number has gone up to 106, almost double that. I'm sure other institutions, and Heidi and Petra will confirm that there's a similar rise, and I see that Alex Festas is also from the ICC in the audience. He can bring in some more fresh information about what happened last year or this year. Don't forget also that a number of states and state entities were traditionally reluctant to submit to institutional arbitration, preferring naturally ancestral rules and ad hoc arbitrations, so there may be more arbitrations there that are involved state or state entities which we cannot measure. Now, what explains this rise? I would argue two things, two concurrent developments. The first is the collapse of non-arbitrability doctrine. Professor Catherine Rogers spoke about that, and you all are familiar with what that means. 30, 40 years ago, tribunals could only review and determine disputes in relation to the performance, the termination, and the interpretation of a contract. Any claims that would involve public interest or public policy were considered to be outside the jurisdiction of the tribunals. Well, now, today, tribunals routinely review disputes that involve claims that pertain to public interest and public policy. On the other hand, a combination of ideological and economic forces led to massive programs of privatizations in the 80s and the 90s. There is an increasing reliance on the private sector currently to perform public functions. Patrizia referred to that earlier on a number of different areas. So you will remember, maybe you've heard, in the 80s in the UK, the massive privatization programs under the Thatcher government, and in the 90s in a number of European states. Now, these two concurrent developments led to an increase in the public private arbitrations, because nowadays many of the standard contractual forms that are used for this concession and infrastructure contracts contain arbitration as the preferred, as a default provision. FIDIC, for example, which is a very popular standard form for concession and infrastructure projects, is favored by a number of multilateral development banks and many states, like Romania. I actually think that in the future we'll see a further rise in public-private arbitrations. You mentioned the initiative One Belt and One Road in China. That will bring certainly a certain connection between the private and the public certain. And I think it should be the case, because despite some of the objections that I have, and I will refer to later on in the context of public-private arbitration, arbitration offers a quick, flexible, neutral, although not necessarily always a cost-efficient dispute resolution method, which is a value for money for the public and generally promotes the public interest.
Would you agree to Stavros' statement, or would you see it rather that the arbitration community now over years become conscious of the fact that the public interests have to be safeguarded?
If I may step in at this stage, I think I would agree with Stavros would say, but I would also offer an additional angle to this. It's true, like we're looking at the same statistics independently of each other, of the ICC. Like 10 years ago, like 62 new cases involving states and state entities, 2006, and then 2016 we have 123 cases, right? So there is an increase. Yet in our surveys, with proportion of all the cases looked or administered by the ICC, of all cases involving states and state entities, remained more or less the same. So there is like a general increase of arbitrations altogether, but the proportion of that kind of cases is still the same. Like so it goes along with like the general increase of use of arbitration in all sectors, right? So the trend continues, but the proportion remains the same. And I think it's also important to bear in mind, at least from the point of view of some jurisdictions, and here in a way I'm representing, like sitting on two chairs, like Latvian chair and French chair, I think it's also important to understand, like at what kind of cases we look at when we speak about public-private interest. So obviously, like these are cases as which we have mentioned, cases which obviously involve states or state entities. But then there are also cases when there's like private party to private party, and yet there are public interests at stake, excuse me, right? And in France, the obvious example would be, like this, like a road concession, construction concession project, and there's a contractor which yet subcontracts something. So whether that private-private relationship, whether we can speak about, like a need to defend and to pay specific attention to the public interest. So I think like the discussion also have to take, at least in some jurisdiction, also those aspects into consideration.
Mm-hmm. That would bring us to look more into the concept of public interest. Would you explain to us a little bit how you see that concept of public interest? And then in a second step, I would be interested to hear a little bit how does it differ from public policy?
Yes, thank you, Patricia, and thank you to the organizers for this very warm welcome, and for also for putting together an excellent program. I'm sure that I can share the co-panelists that we're all, of course, delighted to be here. We've also had some very interesting exchanges among ourselves already on these topics. And of course, this is one of the benefits of being asked to speak. You have to think about these things again and again, formulate an opinion, and think about a very interesting and also complex topic which has been raised. So thank you for that. From my perspective, I will come to it maybe a bit as a pragmatic Nordic person, a Nordic lawyer, and also for me, it's also very important that we keep these things discreet. And even if we have the heading public-private arbitration, what do we actually mean? And that's, I guess, we're teasing out what is the meaning slightly before moving to what will we do about it. And for me, I mean, what we asked Patricia about public policy, ordre public, I think we still, this is kind of some kind of outer limit of arbitration, basically what arbitrators can do, but also what arbitral awards can do, and whether we accept arbitral awards. And ordre public is something, of course, which also in private, developed from private international law, but also in arbitration, has a very specific meaning. And I think that that should still remain the kind of outer boundary, and this is quite a strict. In the Nordic countries of Finland and Sweden, we speak about what is manifestly in breach of the fundamental principles of the legal order. And that's a very high threshold to something to be so against the kind of fundamental principles of the legal system that it would constitute ordre public. And of course, refusal of recognition of arbitration award on this basis is still fairly rare. So, and I don't think we should tamper with that. So we should leave that as, from my perspective, as a discrete thing which we also all know in a sense inherently quite clearly what are the limits. Now aside from that, what is the public interest, what is I think a broader issue. Now of course in ordre public there is also a public interest, the interest to protect these fundamental aspects of the legal system or basic principles of the legal system and not recognize something which we consider inherently wrong or breaching that. But there is a broader public interest that we're speaking about here today in this panel. And this might, of course, thinking about the situation in Helsinki, the very notorious West Metro project is an example maybe of a project which the citizens of Espoo and Helsinki would say that they had an interest in an efficient transportation system, maybe an interest in an environmentally friendly transportation system. Now, is this a public interest that we need to take into account in commercial arbitration potentially? And is it these kind of typically diffuse public interests, rights that we think are somehow relevant in arbitration or even litigious or possible for the basis of litigation in general in the dispute resolution system? I leave that question aside. But I think moving towards my final comments on this question is that from my perspective, if we look aside from these broad public interests, what is the interest of the citizens, we might start to look at these cases where potential public actors, be they directly or indirectly public actors, actors which either states or municipalities or actors and bodies which the states or municipalities have assigned certain roles to or transferred power to or transferred the right to do certain actions to. This is, I think, a matter of, in a sense, from my perspective, a matter of administrative law. How far can you delegate those rights and how far are these kind of bodies involved in private rights and are involved in contracts or disputes which concern private rights? And in those kind of contexts, is there a public interest to take into account? And just to be a devil's advocate to start off the discussion, I think that inherently to have a public interest, there needs to be that public body who first and foremost is responsible for taking that public interest into account, potentially already in the contract. If you see the need for public interest to be involved or then you have to, I think, somehow, I would posit as an argument, put it into the contract or the framework of the civil and private rights we're settling or resolving in an arbitration, which the state sanctions, and which the limits are that it is civil rights that can be amenable to settlement. This is the basis for arbitrability in Finland and Sweden. So civil rights or civil commercial rights that are amenable to settlement. So within that context, if you think that public interest, whatever that is, to efficiency or whatever in the transportation system, you need to put it into the contract. I would posit as a starting point, because how can it otherwise be taken into account? Or we will probably hear, but this is maybe me being a devil's advocate, we have to think about that there are still civil and commercial rights we're resolving in some sense, and that are amenable to settlement.
In regard to what Eva said, would you think, Robert, that there should be an outside limit to the parties' freedom to contract, to limit the private autonomy?
Crikey, well that wasn't on the list of questions that you gave me to think about, but I'll certainly hazard an answer to that. I absolutely agree with Eva's construct there, certainly from an English law point of view. Looking at purely private disputes as between a private entity and a governmental or public entity, it seems to me that the solution should be found in the contract. And so insofar as you want to incorporate a concept of having regard to the public interest, that needs to be in the contract, okay? It seems to me it's not the role of the arbitrators in that scenario to have regard to the public interest. How are they going to do that? On what evidence are they going to base any assessment of what is in the public interest? So it seems to me that you should treat that contract in the same way as any other contract, and insofar as you're expecting the arbitrators to go beyond a pure determination of the parties' contractual rights and obligations and have regard to wider considerations, then you need to make them absolutely explicit in the contract and assist the tribunal in determining how it goes about that to discharge that function.
So you would leave it up to the parties how to deal with public interest aspects in the contract?
Well, yes, I would. And I would say it's also in the public interest, in my opinion, that there is certainty over contractual relationships and that public authorities and governments honour their contracts. And it should be clear what their obligations are and what the counterparty's rights are. And certainly I'm approaching this from an English law perspective. We don't put the governmental entity on a higher plane than the private entity or the private citizen. And that, in my opinion, is one of the strengths of the English legal system, is that we don't have a separate body of public law that overlays or puts the government entity on a higher plane than the private individual. And that's really informs my whole approach to this issue. But that's, I have to say, my view only, and an English lawyer's view, and it may well not be shared by other people in the room.
Can I just interject one thing? That before, I mean, you're not hogging the following topic. I just want to add that it is it is an important issue, but I think it's very important that the governmental body or the party who has this public interest, they have responsibility in the context, as I agree, of entering into a private contract to the extent that they have been allowed to do so and are allowed by the law to do so. Then the public body may have, based on administrative law, rights of control, rights of supervision, rights of transparency or insight into what that body is doing, on how they're doing things. But when they're actually contracting private rights, they are aware that they're doing so. And to my mind, we don't either in the Nordic countries, or speaking from my perspective in Finland, Sweden, put them on a different level, a priori, than other actors in civil and commercial matters.
Well, may I add, like a thought which came across my mind right now. Like I look again at ICC statistics. Like last year or the year before, there were zero cases involving states or state entities with parties from North and West Europe, right? Well, like 5 cases of this kind in 2016. And there were like more than 30 cases each year from Central and Eastern Europe. And then we take North Africa, we take Asia, we take Latin America, so the figures are extremely high, right? So from one side, it means like English government or French government, like in France, there is this provision, perhaps I will speak about it later, that public entities allegedly cannot conclude arbitration agreement. It's subject to interpretation. And, so there are no conflicts of this kind, yet jurisdiction, when states always conclude this kind of agreements. So for me, the question is, for these countries, you tell them whether there is a capacity to, to negotiate and to conclude contracts saying when public interest will be at stake, the arbitrators have to conclude it. The capacity, the administrative capacity, I doubt whether it is there. So, we look at the audience here, whether there's anybody, in this audience representing those governments who would think in this term, next contract we conclude, we will have this provision, specific provision included in the contract. An open question mark.
No, I would just want to add that I've been involved in cases where, at least in the broad definition of we have had here, cases in the Nordic sphere and then in Stockholm where we have had cases where a kind of this type of body which has is also charged with a public function, so to speak, has been allowed or is involved in arbitration. So certainly it exists also, and I don't think there is any general rule on those kind of bodies not being allowed to agree to arbitration. But whether they do on a regular basis, of course, that depends on also certain practices or instructions.
Yeah. Can I
how does
just very, very briefly, just something to interject myself. So you see that there is, although there's different views about whether we should do something and how we can capture the public interest with some laws which go beyond the contract, there are still some considerations that may transcend what is in the contract. Very often, these considerations are captured by what we call mandatory laws and mandatory rules, and they apply irrespective of what the parties have said in the contract. Now, these mandatory laws and rules, including administrative law contracts, public law rules, they apply in every legal system in the world, and they're there because they want to capture the protection of the public interest. Now, there are different ways to do that. There's one way to say, all right, these kind of disputes should not be arbitrated altogether. I think that would be completely the wrong thing to do. So, but still, there is need to somehow make sure that the public interest is not, however, neglected over whatever the parties have agreed in the contract. And I will explain later on my view how this should be the case and why should be the case and what specific threats to the public interest this type of contracts may give rise to.
I would be interested to hear whether England has taken considerations and how does the English law deals with public interest.
I agree here with Rob. They don't deal with that at all. There is the problem with English law, in my view, but to be fair, not only English arbitration law, but a wide range of arbitration laws. They take this binary approach to disputes, to the different range of disputes that now come to arbitration. On the one hand, there is disputes that arise out of BITs or in international investment agreements. All these type of disputes are automatically subject to public international law. On the other hand, there's all other types of disputes. So they're considered to be contractual. However, and they are subject to a contractual way of resolving these disputes. However, this binary approach, public international disputes, and all the others that should be considered as contractual, fails to capture an increasing, growing middle ground, which is the middle ground of public-private contracts and disputes that arise out of that. Now, these types of disputes that are classified as contractual They don't give, they're considered not to give rise to any kind of public interest, and they're treated completely in the same way like any commercial other contract or any other commercial dispute. In the way that arbitrations are conducted, in the way that evidence is taken, in the way that the tribunal, what the qualifications the arbitrator should have to decide these disputes, what laws should apply, whether these disputes should be subject to confidentiality or transparency, whether there should be any intervention by any other third party which has a private interest in this dispute. Also, at the time that the award is issued, the way that these kind of awards have arisen out of public-private arbitrations are in the same narrow subject review that any other arbitration, contractual arbitration. Under English law, you have serious irregularity, section 68, lack of substantive jurisdiction, 67, and public policy. I leave aloud the 69, the review on the issue of law, which is not used too often. And the public policy also ground, and Eva talked about it, is a very legal concept that does not necessarily capture the public interest. So the review there is very, very narrow, usually only on issues of illegality. So you see the whole legislation, the framework of legislation, not only in English arbitration, I repeat, in many other arbitrations, they fail to capture this middle ground of public-private contracts that, in my view, give rise to important public considerations, public interest considerations, and they treat all of them like private contracts.
Mm-hmm. Do you think it's in England in particular more difficult to find specific regulations for this narrow sphere because of that implied duty of confidentiality in commercial arbitration, which is rather unknown for civil law jurisdictions?
I think that this is the case, again, not only in England. I don't want to focus and be unfair. I mean, I think the English Arbitration Act works perfectly well on the vast majority of the disputes that are commercial and contractual disputes. This is the right approach to that. Party autonomy in these kind of contractual disputes is the absolute cardinal principle that should apply. But for these kind of disputes, I think there needs to be a different way to treat them because they can give rise to two different threats. Mm-hmm. Well, the first threat to me is the potential non-applicability of public law rules. And I mentioned previously that public-private contracts are not commercial contracts. They're hybrid contracts. They're somewhere in between public law and private law. And this is now widely accepted in all legal discourse. So accordingly, these kind of disputes may give rise to disputes, these kind of contracts may give rise to disputes that may give rise to conflict between contractual law and public law. Let me give you an example. In a concession contract with a private party about the provision of water of public transportation service, and let's say that in the UK, the next government is elected on the basis that they're going to nationalize again these private contracts, right? And I have to say, it's not a remote likelihood. The Labour Party, which may win the elections, have publicly said they're going to renationalize all of these private contracts, the privatization contracts. I'm not questioning here whether this is the right or the wrong approach. Personally, I believe it would be absolutely the wrong approach to renationalize. My question, however, is that if a government is elected on the basis that they have the mandate to renationalize all of these contracts, then this government should be able to do that. And irrespective of what the contract provides, there should be some application of public or administrative laws that allow the government to move away from this contract, even if this is not something that was provided in the contract itself. In the UK, for example, we have the administrative law concepts of ultra-virus, of the rule against fetering. I'm sure that every legal system has its own administrative law concepts. So what would be the case if this contract was to be going to arbitration? Would these mandatory rules, administrative or public law rules, would apply? I don't think so, for the reasons that Rob and Eva said. I don't think they would apply to these contracts because arbitrators don't have a duty to apply these rules if these rules are not specifically pleaded in the arbitration. The second thread...
But can I interrupt you on that?
Yeah,
Sorry.
for sure.
Most public works contracts in the UK, government-led public works contracts, will have a termination for convenience provision in there, which gives the public authority the option to terminate without any justification, but upon payment of agreed compensation. Right?
And that's
so
right.
that is an available option. If they choose not to do that, then, and they put themselves at risk of breach of contract, then the ordinary consequences would flow in terms of a damages award. But there's a ready-made mechanism in these contracts to deal with the scenario that you've just described. It may be an extreme, but potentially, want to come to fruition in terms of nationalisation. The contract will regulate for that scenario.
Absolutely, and it's the right thing to do.
Problem.
To do also contractual. The question is, if these kind of clauses are not inserted there, what is the solution? That's the question that I'm debating.
Right.
And the question that you just said, whether the public sector or the public body there, makes good use of this clause, leads me to the second thread, which is the issue of confidentiality that applies in these contracts. And you know that these public bodies and entities have the power, are given the power, and how they exercise this power, it should be exercised in the interest of the public. Now, if this is not the case, and we don't know how these principles will be exercised or how the public will do that, and I here agree with Rob in the exchange that we had, that public bodies tend to abuse the issue of confidentiality and the principle of confidentiality, and we don't know what the decisions of some governmental authorities have been. If these decisions have been detrimental to the public authority, to the public interest, to the taxpayers, we need to know about this. We need to know what went wrong in some of the arbitrations that eventually the public had to foot the bill. But this is not the case currently.
That brings us actually to one specific case that we can give you as an example, and Rob has been involved in that case, in England, the EBorder case. And it was in the public domain. It triggered a lot of discussion about public interest, and so you're allowed to a certain extent to introduce you now to the key issues, to the case and what impact it has on public interest.
Happy to do that. Stavros cites this EBorders case in a very interesting article on these issues as an example of why there's a problem under English law, and I would challenge that proposition. And perhaps to debate this, we should just have a little bit of a summary of what that case involved. Not everybody in the room, I'm sure, will be aware of it. And I must start by probably almost making Stavros's point for him, which is that I was lead counsel in the case, but the matter, although long over and settled, is still subject to some confidentiality restraints. So I can't disclose all of the details, and I won't do so today. But the key points, just to remember, were these. The EBorders contract was between the UK Home Office and Raytheon, and I represented with my colleagues Raytheon in that dispute. And it involved the supply of a state-of-the-art immigration control system to the UK government. And the Home Office purported to terminate the contract for default at the height of the Cameron government's austerity drive. And the government argued that they were justified in doing so on the basis of extensive delays and cost overruns on the programme. And Raytheon's position was, yes, there were delays and yes, there were cost overruns, but those were attributable primarily to the Home Office itself and other government stakeholders. Now, the matter was referred to LCIA arbitration in London, but not a lot of people know this point. The contract had an option clause in it in terms of dispute resolution. The government had an option to choose between going to court or to go to arbitration, whereas Raytheon only had the option to go to court unless the Home Office agreed to go to arbitration. It had to go to court. The Home Office started the arbitration, not Raytheon, and it did so that it could go to arbitration and take advantage of the arbitration provision. And I'm sure part of that decision was around the confidentiality of the process versus having to air the matter in open court. So we had an arbitration. Raytheon won the arbitration. Then the award was challenged successfully at first instance in the English High Court, and Raytheon appealed to the Court of Appeal, but the matter was never heard on appeal because there was a settlement, and Raytheon was paid 150 million not US dollars, pound sterling, much better. And that was the end of the arbitration. So that perhaps sets the context for this discussion.
Mm-hmm. And why did it raise such public awareness and the discussion about how the public interest should be taken more into account?
So, I mean, I think it's Stavros's theory that this case highlights two problems. And I agree with him on one, and I'm not so sure on the other. It could be cited as an example of where the tribunal should have, but didn't, take into account the public interest in making its determination, and it simply determined the issue under the contract. And that really comes back to the point that I made earlier, which is that in the EBorders case, there was a termination for convenience clause in the contract. It would have been open to the government to invoke that clause, terminate the contract. There's no restriction on its right or the timing of that termination, but it would be required to pay contractual compensation for that decision. But it chose not to do so. It argued unsuccessfully that Raytheon was in breach of contract, and it followed, as a matter of ordinary principles, that it was liable in damages for that decision. I don't see any problem with that outcome. I don't see any room for any considerations of the public interest. I don't see how the tribunal could have evaluated the public interest, what evidence it could have relied upon, etc., etc. And it wasn't within its remit because that wasn't the issue before it. It was simply determining whether or not the termination was contractually justified. The second element of it, however, I think is more debatable around the confidentiality of the process, because the starting point is that the arbitration itself was confidential. The proceedings in the English court on the setting aside application were also confidential. On top of that, just to make absolutely sure that matters did not leak out into the public domain, the government went to court and succeeded in getting effectively a gagging order over and above whatever restrictions were already imposed on the parties in their counsel to stop any leakage of information into the public domain. It might have had something to do with it that the Home Secretary at the time was Theresa May, our now Prime Minister. Maybe she had some reason to avoid public scrutiny. But anyway, that is something which we had to live with. So only limited details are now in the public domain. Some details are there because the LCIA rules permit disclosure, so Raytheon disclosed the outcome of these disputes in its accounts. The government disclosed the outcome of the dispute to Parliament and to the Home Affairs Select Committee, but only limited details are out in the public domain. So you could argue that the public interest might have been better served had more details been put out there, but one comes back to the fact that in the contract there was a confidentiality clause. The parties could have negotiated that differently, but that, I think, is what I come back to, is that the government could potentially be criticised for having put that clause in that contract, but, you know, that is the consequence, and the private party, Raytheon, also has an equal interest in having that agreement upheld, in my opinion.
Just very briefly, because I'm grateful to Rob for all these details, which is some of these. It is the first time that comes to light. And actually, it reinforces many of my concerns on a number of reasons. The termination of the contract apparently was there, and there was a clause there that could terminate on the basis of convenience. The government didn't do that. There was also a confidentiality clause that was inserted in the contract by the government. The government had to be scrutinized over that. So there are a number of issues that eventually resulted in a very bad decision on the government side that eventually led to 150 million pounds to be paid by the taxpayer, and we don't know nothing about what went wrong and why did the government took this decision. Public and administrative law, I should remind everyone, is there to protect against the abuses of the authority of the governments. It is there to protect the private parties and the taxpayers, and I agree very much with you, Raytheon had the right to be protected. But it's this reason why we need to know more about what went wrong in the terms of the government, indeed, Theresa May, and if anything went wrong, then accountability should ensue. There's also another very interesting detail here. The government challenged that, and as Rob said, won the challenge at the first instance. The High Court found that the award contained serious irregularities and major flaws. The Raytheon, as you would expect, appealed, and then all of a sudden the government decides from 230 million, that was the award, to pay 150 million, having won the first instance and before going to the Court of Appeal. Why? Why this decision was taken?
Well,
we know nothing about that.
Lost the appeal.
Fair enough. You would say that, and that's absolutely
outrageous
fine.
decision by the first.
But we need to know more about this decision of the government, and this is not what currently happens, and that reinforces, I think, the point.
Yeah. One comment from Eva, and then I would also like to give the audience the opportunity to share comments with us.
No, I think this is a very, very interesting debate, and this shows maybe from very different starting points we're coming at this. But I would say that Stavros mentioned mandatory law, and I didn't want to speak about mandatory law in my first intervention, but I think that mandatory law's applicability in arbitration is, of course, a very complex topic, but that it is not impossible either and it's not uncommon either or unknown nowadays for arbitrators to take into account and rule on matters regarding mandatory law to the extent that they affect the determination of civil commercial rights. So there is nothing inherently problematic, I think, about that, and that doesn't, the fact that there are mandatory or elements to a dispute doesn't mean that it's not arbitrable, and it doesn't mean that there is inherently a problem. But I would also note that from my perspective, the problems of the British government in the particular case can be probably better addressed rather than in the commercial dispute resolution. The choices they made there, they can be held accountable in other ways in administrative law by the citizens, either politically or maybe even challenged on various grounds of bad use of authority of government.
How we do know?
Whatever rules they have. But of course, in the Nordic countries, we would know because there is much more transparency of public administration in general and much more rights and possibilities to get information. And then, of course, also inherently, the parties are not either bound by confidentiality and arbitration based on the law, unless they themselves agree to it. Inherently, a lot of the problems that arose in that case probably wouldn't be as aggravated in a Nordic context.
Mm-hmm. Does the audience have any comments to share with us? We have here. Do we have a micro to forward?
Thank you. I have a question. You have been discussing around a question that I have, and that is that these contracts many times or most often involve governmental functions that the government transfers to be handled by a private party. And these functions are regulated by the administrative laws, and the exclusive competence to determine whether the function has been properly handled is with the administrative courts. Now the question is, do the arbitrators have the competence to resolve whether the public interest as regulated in these laws have been met?
Interesting question. Would you like to?
I think I already said, I think they should be able to address that. I mean, now it's common ground that tribunals have the authority to deal with these issues. I think, however, the framework for dealing with these issues should be somehow different than the pure contractual framework that currently applies. We need to have a slight distinction in the way that these arbitrations are treated, but this should not be a reason to take these arbitrations away from these disputes away from the arbitration sector. It would be a very bad mistake. As I said, arbitration offers a flexible, neutral, and timely dispute resolution that eventually serves the public interest.
Now we are doing a little lawyering here. Do these public entities have the power, I would question that, to convert a public function into a commercial function?
Can I?
Yeah, sure.
I mean, in preparation for the day, I started to reread a lot of Finnish and Swedish administrative law, and of course the very interesting question, of course, that Robert puts to us is that what happens if that kind of the power or the kind of transferring of power or governmental obligations or municipal obligations, is that allowed in the first place? And what happens if it's not allowed but it still happens? And that is, of course, a very, I think, a difficult question, but not necessarily one that is inherently solved in arbitration, because we do have administrative courts, courts to deal with that kind of if one actually transgresses the power given to the body, and that they are not allowed to transfer the powers. But I think that a lot of the cases are actually, I mean, a bit devil's advocate again, a lot of the cases are not actually about public functions, because in our systems you cannot transfer public functions to private bodies, and they cannot in a general way become private rights. What we're settling in arbitration, what the government has allowed government sanctions arbitration in its Arbitration Act to settle civil law claims that are amenable to settlement. The question of whether a public body has transgressed its power is not a civil claim which is amenable to settlement. It's a matter of administrative law and should be dealt with by administrative courts. Whether that kind of problem could be taken into account, whether the validity of that contract is null and void inherently and should be taken into account in a potential arbitration if such a transgression has happened, is a difficult question. And then comes the question, if it's null and void, should the arbitrations take this into account as some kind of mandatory law? And this is a difficult question, but I would argue that very carefully that might be possible.
I think that would be the right analysis. I think you would, again, probably simplifying it far too much and possibly wrongly. The decision-making power of the public body would logically be, if it was impugned, attacked, challenged, would be within the scope of the jurisdiction of the administrative courts, where the legal system in question has those administrative courts. And if the decision was nullified for being ultra vires or whatever the principle was, that would, one would have thought, be then taken into account by the arbitral tribunal if it's dealing with issues in relation to the underlying contract, where they're determining a different issue, which is the contractual relationship between the public body and the private party. So that's where the two systems intersect, and I think perhaps that's where you've landed in your analysis, Eva.
Yes, but the difficult question is if that contract, if our legal system would perceive that contract itself to be null and void,
right,
based on the fact that they didn't have power to give the authority to the private, or didn't have power even to enter into the contract, and whether this can be taken into account as a matter of some form of mandatory law. And that I haven't got a final answer to, but this is certainly, probably depending on the seat and the applicable law, arguable both ways. Certainly a tricky question, as all mandatory law questions are, but not inherently impossible, I guess, to take into account as a matter of mandatory law.
France is taking a very specific approach.
Right.
Could you describe
I will
that?
get into this, but developing also on what Eva have told, like on what she has said. I think the question is also, if none of the parties raises this kind of defense, is it up to the arbitrators to raise this defense sua sponte, right? Do I have rights, obligation, a duty, like to do so? And then if so, at what point of time, like, because if I do it just in my final award, then everybody is taken by surprise, and then this is, like, probably a justifiable grounds for setting it aside, and then maybe the position is safe when I bring the point to the parties and say, hey, like, actually pursuant to applicable law, this kind of a contract, it's administrative contract, it cannot be arbitrated, so I don't have possibly jurisdiction, please comment. And then you can face another type of challenge. So whether arbitrators, like, what should be their action? Like, I sit and I hear, and then with the risk that the word will be set aside, like, I damn if I do, I damn if I don't. I think, like, this is the status quo right now. And thinking also in terms of scrutiny, for example, by the ICC court, right? How it normally goes. Like, if you raise something on your own volition, well, it might go ultra petite, like whatever principle, like as Rob had mentioned. So where are we? Like, so it's will depend on whoever parties, what is the applicable law, who are the arbitrators, and arbitrators in plural, like, and how do they approach this thing?
Difficult question whether this is within the scope of the arbitration agreement.
Right.
Yeah.
Well, but going to to your question, Patrizia, like, what is the situation in France, and maybe linking it to the next question, as we have discussed, what is the optimal way of dealing with this kind of matters? Probably, like, well, we'll see if there is an optimal way. It seems to me that France may be not the optimal way right now, right? Because in France, as like, and I try to convey the message as clearly as possible, bearing in mind that the situation is not clear at all in France, right? So from one side, there is a general prohibition, or at least as it is interpreted this way by part of practitioners and part of scholars in the Civil Procedure Code, which says basically that states and state entities cannot conclude arbitration agreements, right? Yet, this general prohibition is rigged by exceptions, right? So there's like numerous exceptions, different laws passes, or like for different events, etc., etc. So there is a possibility for like certain entities in certain situations to conclude administrative contracts with private parties, and then we come to the next, division in French law. What exists, like, okay, there's like, we have administrative contracts with French entities in arbitration agreements, but for arbitrations with seat in Paris or with seat in France, but yet different regime will apply if this kind of arbitration is seated in a foreign country. Right, and all this comes into picture, like in different, yet in our picture, that in France we also have civil courts and administrative courts. So at the end of the day, who is controlling whatever, like public interest and then public order, because public order is so important in France, is controlling that everything was observed. And this is the situation which is, like, it kind of like clear answer from one side was given by French courts, from another side the answer is not that clear. So in the last years, like specifically 2015, 2016, was like a number of decisions by the highest administrative court in France and the highest civil courts in France, like, so Cour de Cassation, like for civil court, and Conseil d'État for the administrative court, like, what is the authority of, of control, which courts should control whether the public public order and public interest were properly observed. So for today, the status quo, like the answer of French courts is, if there is an administrative contract, for the executor of arbitration awards rendered in cases pursuant to administrative contracts, you have to go to French administrative courts. Even though the basic rules, like normally for the execution of arbitral awards, we should go to the civil courts, right? But for setting aside of this kind of cases, you will have to go to the administrative courts only for cases which took place in France. If this kind of arbitrations where it took place in somewhere else, you have to go to the general civil courts. So how confusing is that? Like I went through this many times, and I still have difficulty to convey this, right? And this is equally confusing for French practitioners, which obviously impacts, like the discussion. Paris is a place for arbitration, yet. Not everything is perfect. So maybe, like it's one solution, one way of going, but is it an optimal one? This is a question mark. But it seems to me from what you also presented, like England, for the time being, neither presents an optimal way of dealing with the things. So we probably have to look for yet alternative ways, Nordic maybe way.
Yeah, what would be your... Do you have a comment? No, sorry.
Ralph Lindbeck from Wärtsilä Corporation. I have a very short, quick question. Statistics and trends which you mentioned here. Question to the panel. Have you seen a trend that when you deal with public interest versus private proceedings, that they settle more frequently than when we have private versus private? And if there is a trend, do you have any explanation why that is the case? Could you please elaborate a bit on that front line? Thanks.
I don't have empirical evidence to support any case, and the Queen Mary survey was mentioned a couple of times. This is not something that we've looked into. So, I have personal opinions about that from the case I have seen, but I don't think I have any empirical data. I don't know, maybe Rob has more.
A couple of observations. I don't think I'll necessarily answer your question, but I'll try. I have no statistical reference point on this, so it's a matter of pure personal impression. I would say also I'm not entirely sure it's right to say there has been a rise in this phenomenon. I mean, in my whole career, there have been what's now being described as sort of public-private disputes and arbitrations, so I'm not sure it's right necessarily to say there's a lot more of them than there were before. I just don't know. Maybe there is. In my personal experience of these cases, and there have been quite a few over the years, it's quite hard, possibly harder to settle a dispute involving a public authority or a governmental entity, because the mere fact of making a decision to settle the dispute could open those public officials to criticism. And therefore it's easier for them not to make a decision and let the arbitrators decide. That's my experience.
That's also my experience from a couple of cases that I had, especially pertaining Eastern European cases and countries. They were very, very hesitant, indeed reluctant to settle, even if they had a strong case at hand, for the reasons that just Rob said. So that's my personal experience, Ken.
And I would just add that this is also my observation from practice, and maybe also this, in a way that you can maybe see from these public bodies, different depending on what they are and how the entities, that their decision-making processes are more complex maybe in some instances than in private companies, which means also that these kind of negotiation processes might be more complex or less functional to reaching a settlement, basically.
Yeah.
I understand. So I draw the conclusion that when I'm viewing this from the private side of the fence, that if I do have a public interest in front of me, the interest is for them to run the race to the bitter end. Is that correct? If you need, the public interest needs the award.
Ooh, that's an interesting point, because now actually the public interest probably is for the public officials to take a sensible view as to what the outcome of the case will be, make a risk assessment like a private party would.
Exactly.
And if it's a waste of taxpayers' money to pursue the case, they should not pursue the case. But rarely do you see that level of insight and, if you like, professionalism around that question. Yeah, you more often see, I mean, probably it's a bit of a caricature of this, but more often see a head in the sand approach and let the matter be resolved ultimately by the arbitral tribunal, because they're less likely to be criticized for that.
Understand.
And I think I absolutely agree with this view. I think they should be able, the governmental officials, to take a decision on the basis of the facts. The only question I have is that they should have this opinion to be scrutinized by the public. The public should know on what basis the decision was made, and eventually it would be for the public to determine whether the decision by the governmental official that was taken to settle or not settle the award was or was not a waste of time of the public.
Got it. Now, we are running out of time, but my comment on a related subject is that the public interest indeed may grow here in some instances. Take, for instance, climate change, where, what exactly is the public interest and, how to protect it. I don't expect any comments from you, but just as a sort of observation that the public interest is definitely not static. It's probably growing, especially in this field. Thank you very much.
Thank you. Any other questions? Please.
Thank you. Matti Tyynys, nimi Hannes, Nelman, Finland. Just to actually continue from the last point, this is, I guess, maybe mostly a question to Stavros. Regarding this Raytheon Home Office case, which I found very interesting, when I listened to the issues you raised, isn't it so that in the end all of these kind of public interest issues, they arise at the government's end from decisions made by the Home Office in negotiating the contract, in choosing where and how to terminate it, initiate the proceedings to settle the matter. So I find it hard to find how the issues could or should be resolved by an arbitral tribunal or by arbitration law. Shouldn't they be kind of handled at the government's end and made to make sure that the government can be held accountable for whatever actions they have taken, and that the necessary information is made public?
I absolutely agree. And I think that's the whole point of transparency, is how decisions were made and whether these decisions, in the hindsight of the facts that intervene in the meantime, were the correct decisions or not. I mean, that's the same applies for any decision. If Mike takes a decision to settle or not settle an award in the arbitration, he will be subject to the scrutiny of his partners or his shareholders. Shouldn't be the same with the government? And that's exactly the point. And we don't have this information to judge whether the government did or did not take the right decision in this case. And that's the whole point about that.
It's worth mentioning too that if you can't get this information through Freedom of Information Act requests either, because that is always blocked on the grounds of confidentiality. There's a question over there, I think. Somebody put their hand up a moment ago.
No, it was
Down again.
Petra or Alex? Yeah. No?
Maybe we can do it together. Thank you so much. I have to be a little bit provocative, and I'm sorry to disagree with a fellow Grecian, but I will. I think this may not be the right case to comment on the limits that confidentiality imposes in a case that public and private interests clash, because here you actually have national security. If I was a state, I wouldn't necessarily want anyone, including my citizens, to know how they can actually break into the country. So I suppose that this may actually set the limit, and there I have to agree with you, Robert. But then, if the High Court judgment that considered that there was procedural irregularity, which we don't know exactly what it was about, of course, but if it did admit, if it did set aside the award on the basis of a serious irregularity under the Act, that means that that is a question of process also, to a certain extent, I assume. And maybe moving away from a substantive issue, I would like a comment with regard to whether striking the balance, which is part of the title, actually require, in a commercial arbitration setting, actually requires taking into account the existence of the public interest. I remember a case where a tribunal had recently issued a very, very well-reasoned procedural order on document production and time limits in the case, where in the existence of a state entity arguing that its own organizational means would not allow it to meet a time limit that would have been equal to the time limit that the private party would need to open the warehouses and examine documents. It actually considered that party equality could be affirmed by giving the parties an equal period of time to prepare. And that was actually not challenged. So maybe, given that commercial arbitration is something that changes a lot, and it changes, it's an evolutionary process, maybe that is something that, beyond substantive law, in terms of the process, we need to take into account. And also because, and going back onto the substance, public interest changes a lot. It's not just the existence of the state in the case. It may also be a change in policy of the state. What about all the investor-state disputes from Latin American states that have terminated their BITs and are now coming back by way of commercial contract? What about global goods, environmental disputes that don't necessarily pertain to any specific one single carrier of the right or any single state? Those are cases where we will find very, very solid affirmations of public interests. Thank you.
Thank you very much. One final comment of you?
So I was waiting for an answer first, but yes. Okay. So
I was waiting for a question.
I would say we hear your comment and then give you the answers to both of your questions.
This is both a comment and a question, maybe. Listening to you, I kind of found two different questions. The first related to confidentiality, and I think the discussion just before was that the main problem that you voiced with public interest is that the public needs to know what the government does. This is sort of topic number one. And the second topic was with regard to how and if the arbitral tribunal should apply different types of public law. And I think those two are completely different issues. The first one should be a simple one. I think if it's a question of confidentiality, you're always free to decide that your arbitral proceedings are not that confidential. So I don't really see that to be a problem with arbitration or something that should be changed within arbitration. It's a question of agreeing to more open proceedings, for example. The second question, of course, is a bit more complex. But if we leave the mandatory law aside, what's the difference? I mean, if you have a commercial contract, whether you are in the public courts or in arbitration, you look at what was agreed, what is the applicable law, what are the applicable rules, and there again I kind of find it hard to see the difference. I mean, if we talk about the Nordic countries or UK, for example, you wouldn't have a general court going completely outside the contract, applying something that was not there, that was not part of the parties' agreement. Or am I mistaken?
Can I?
Please. I think we have 1 minute to go, then we have run out of time, unfortunately.
Just on the Petra's last point, that was what we said from the beginning, that if there is a public interest and the government body enters into a civil contract and wants a public interest to be taken into account in some manner by either a court or arbitral tribunal, they should cater for that in the agreement in some way, because we cannot, as you say, cannot go bananas of our civil rights unless we have tangible civil rights which we feel that they are able to apply in a kind of so. But that might, of course, evolve. Our civil law might evolve to take into account more public interest, or we might want to evolve that, or we might want to amend our contracts to that matter. So that is that doesn't necessarily have to be static, but it cannot be just something diffuse out there. That was my observation.
Well, it will take me a lot of time, and I think I explained what is the problem both with confidentiality and with the applicable laws. With confidentiality, the question is why the government took the decision to go confidentially. That's a very important issue, and we need to know. In regards to applicable laws, the national court would apply mandatory laws, even if they are not pleaded. If the mandatory laws apply because there's a public interest here. It's not necessarily the case with arbitration. In a very, very brief comment. With regard to Alex, I think despite his prefacing his comment with disagreeing with me, I think we effectively agree. I think the process that you described, the evolution of the process that you can see there in many other arbitration processes and types of arbitration will evolve. And it will evolve to protect the public interest. And I think that's the last point I want to make. You see that the writings are on the wall. For investment arbitration, for example, who basically have the same considerations, although there's public international law as a law to public law, you will see the clear direction, both in terms of transparency, we all know the impetus of the Mauritius Convention, but also in a more effective protection of the right of the state to regulate. You will see, not only in the conventions, the agreements that the European Union tries to sign, but also in new versions of BITs, the Dutch BIT more recently, they have a more narrow scope for what is fair and equitable treatment, defining more narrowly what is legitimate expectations. So I think these trends that we can see in public international law and investment arbitration will effectively come along to public-private arbitrations.
Mm-hmm. Thank you, Stavros, for your concluding remarks. We have already quite been interfering in the schedule of the conference, although we could continue discussing public-private arbitrations for another hour for sure. Thank you for your patience. Thank you for joining in our discussion, and we'll have a short break now of half an hour. Thank you.